be seated. We will hear first from the petitioner in Highway 98 Residential, Inc. against Adams Homes of Northwest Florida, Inc.
May it please this honorable court, my name is James Gassenheimer. I'm from the law firm of Berger Singerman. I represent the petitioner in this action, Highway 98 et al. And this is my first time appearing before this court.
Well, let me tell you, if you want to reserve time for rebuttal, if you'll tell us how many minutes, we have a very alert clerk who might help you with the lights here.
Great. I would reserve 3 minutes for rebuttal.
Okay.
May I proceed?
Please.
Thank you. Your Honors, we are here today to endeavor to create a level playing field for my client at the trial court level. I would quote from Judge Harris in the Torres opinion to try and set the stage for my argument, and his concurring opinion from the 5th DCA. If one knows that he or she or it is about to become involved in a civil action, this alone should be sufficient special circumstances to impose a duty to preserve such evidence that a reasonable person would foresee is material to the action.
You're not actually contending that any evidence was not preserved, right?
It is our contention in this case that evidence was not preserved.
Can you describe that evidence for me?
Absolutely. The evidence in this case is internal, is a broad spectrum, but the most important to us is internal email communications between the senior level managers of the Appellee Corporation. And to explain, to put that in context, this case is about a dispute between a horizontal land developer and a home builder who'd entered into a series of contracts to develop large tracts of land, undeveloped land, into residential subdivisions and communities. This involved millions of dollars and thousands of lots.
Are there specific emails that you claim are missing?
Yes, in fact, not only they're missing, they're admittedly deleted from the system.
What emails are those?
These would be the senior managers described in their deposition testimony that they communicated among the various regional offices by email with respect to the treatment and interaction with my client among themselves. And they admitted that on a weekly basis, or some of them on a 30-day basis, would go through their inbox, their electronic mail inbox, and delete all of their emails. At some point, or specifically, our contention is that when it was decided that they were going to declare these contracts in breach and sue my clients, that they should have stopped this process of deleting their emails and kept them or maintained them, that they were critical evidence to their internal thought processes and the way they were treating my client. And specifically to orient the court in the theory of the case, the issues in the case are anticipatory breach of a contract. In January of 2007, in the period of 2003 to 2005, a series of contracts were entered into between the parties in which
specific performance contracts that basically said, if my clients built out these subdivisions, you'll buy. Can I ask you a question? Now, Adams Homes, his employees testified that they've turned over all their pertinent and relevant emails to their attorney, right? So the question to you really is, if you think that's not true, specifically which emails are you talking about? I mean, do you have a particular date of an email that you're concerned about, or a particular email from one person to another? Because otherwise it almost sounds like speculation. It almost sounds like you think that there must be something that was deleted. And the narrow question to you really is, which email are you talking about?
The specific emails we're talking about are the communications between the regional managers of Adams Homes, between the various officers, discussing the relationships with my clients. The testimony specific
During what time period?
during the period from the time, we contend from August of 2007 until the time that I took their depositions in the summer of 2009. The testimony was that they had a...
So you mean, you're talking about emails that were transmitted even after the lawsuit was filed?
That's correct. I don't have the emails because they were deleted. In the electronic, in the concept of electronically stored information or this email communication, in today's world we communicate by email, not letters.
Now, do you have a case that says this duty to preserve evidence has implications for work product or other correspondence that occurs after a lawsuit is filed?
Well, there are several cases that discuss the concept of when does the duty to preserve evidence attach. Certainly in the Strasser opinion from the 4th DCA, the sending of a discovery request, as we did in October of 2008, asking for all electronically stored information, in the Strasser case would say that the duty attaches. In the Torres case from the 5th DCA.
But that would be going backwards, right?
Going backwards in time.
From the date of your request.
Correct, Your Honor. So in the Torres case, we dealt with the situation of a vacuum cleaner that a plaintiff negligently lost.
So in this case, so you would go back a week or maybe a month, you're saying, with respect to some of the employees, and that would be the window in which there might be something discoverable that should be preserved.
My argument is from the time...
And by the way, is the duty to preserve something that might be discoverable, or is the duty to preserve evidence that is material to the case?
The duty to preserve would be what a reasonable person would presume would be relevant to the case. In this case, it would be the emails of the 18...
What is it that is relevant to this case that you can tell us was not preserved?
By the admitted testimony of the senior managers, they deleted all of their emails continually until the time of their deposition, a year and a half.
And which of those were relevant to the case?
In the context of this case, we don't have the emails. They were destroyed. So we don't know.
You really can't say that any evidence was not preserved that should have been preserved.
A fundamental.
Is that correct?
I can't say what was in those emails because I don't have them because they were destroyed. Just like in the vacuum cleaner case in Torres, we can't say whether the vacuum caught fire because of lint from misuse or because of a design defect in the product, because we don't have the emails. A fundamental principle to our trial system is the right to confront witnesses. In a breach of contract case where anticipatory breach is the issue, my ability to confront these witnesses on what they were really, what their thought processes was, or my unjust enrichment claim, my equitable claim, whether they were acting in good faith or bad faith when they declared my contract in breach, has been completely eviscerated because their internal thought processes, their internal email communications have been destroyed. So I don't know whether there was stuff in there that was helpful to me or not.
So you're saying they should have, that they had an obligation to retain everything?
I'm saying they had an obligation to retain all email communication among the key employees, as is discussed in the electronic discovery cases that I've cited to the court in my papers. Once you decide to declare a contract in breach, those key employees, in this case the 8 key employees who were communicating among themselves throughout this 7 or 8 months of negotiation that went on before the suit was filed, were critical evidence that a reasonable person would have foreseen that we would have wanted to review or
you're talking about critical evidence, and yet you can't even tell us how it would be critical.
Well, in the same way that in the Torres case, we couldn't tell whether whether it was lint or some other reason why the vacuum cleaner was destroyed, or in any of the other spoliation cases.
No, but that was a product's liability case. You had to have a product. That's what that case said.
What would you hope you would have found in emails had they been preserved that would be relevant to the case?
For example, if the emails had discussed the fact that since we've terminated these contracts, our sales have, we've started to see an uptick in sales activity because people are no longer worried about a whole bunch more lots being developed and therefore the prices of not being able to control the price. I mean, you're asking me, I mean,
Isn't there other, are these emails, you're talking about sales, aren't there going to be accounting numbers that would demonstrate that? Isn't that a fact demonstrated not by what people are talking about, but by what's in the books and records?
As the case is currently situated, I'm confronted with the issue of key employees of a company who want to keep their jobs, who will testify against my clients, and having no opportunity to meaningfully cross-examine these witnesses because their paper record of what was going through their minds during the critical time in the case doesn't exist anymore. The financial records may support an aspect of the case, but they do not support the critical aspect of the case, which is what was going on at this company that made them decide to anticipatorily breach my client's contracts, to terminate my client's contracts.
But, if you can't tell us precisely what's been destroyed, it almost sounds like you're going on a fishing expedition. It's almost like you're saying, well, let's just see what you have here, and maybe this is important, maybe it's not, but let us just take a good look and see what you've got here.
I would answer your question by saying, is it appropriate to allow senior management employees at a company that's being sued for millions of dollars to decide which of their internal memos they're going to keep with respect to litigation that's subsequently filed? Or should all their internal memos be kept so that a neutral arbiter can hear both two advocates argue?
It seems like it's a narrower question than that, because it seems like it's an issue, it's a question of spoliation, which is much narrower than should they be required to maintain their records.
Well, the issue is that the records were spoliated. The admitted testimony of the witnesses is that we deleted all of our emails on a regular basis and only kept those that we thought were important. So we allowed the senior management employees of this company to decide what was important. It would be to say, do we want the law in Florida to be that before a company decides to sue for breach of contract, we allow them to wipe their hard drives so they decide what evidence will be available in a trial over the breach of the contract? In our electronic age, where we no longer keep hard copies, we go to a paperless system, the email communications, the electronically stored information is the evidence on which we have to try these type of cases. And it can't be the law in Florida that we want to say that a company should be allowed to elect to wipe out the memory of the hard drives of their computer systems, wait until the verge of the statute of limitations running, and then file a lawsuit. You are preventing the system. I would argue that would prevent the system from working, from allowing trial lawyers, advocates to take the paper record or the electronic record and advocate their client's position and let a neutral arbiter, the trial judge or a trier of fact in the jury, decide what the relevance of those emails are.
Mr. Gassheimer, you're into your rebuttal time.
I would ask at this point the court allow me to reserve the remaining time.
All right, fine.
May it please the court. I'm Alan Bookman with the law firm of Emanuel Shepherd & Condon in Pensacola, and we have the privilege of representing Adams Homes of Northwest Florida, the appellee in this particular matter. The standard of review that this court has to address in this petition for writ of certiorari is whether or not Judge Swanson, the trial judge's order, did it depart from the essential requirements of law, and did it cause irreparable injury, adversely impacting or affecting, in this case, the appellant's opportunity to prosecute their case. And I think from the questions of Judge Clark that no, they have not shown any irreparable injury as far as their inability to prosecute their claim. This is, as Mr. Gassheimer indicated, there were multiple contracts between the Adams Homes, which is a home builder out of Northwest Florida, and a number of 5 or 6 developers, the principles of which were all the same in various counties throughout the state of Florida, involving thousands of lots and millions of dollars. He is correct in that regard. That's what this case is all about, as to whether or not our client breached the contract or the developers breached the contract. And the fact that these alleged supposed phantom emails containing unknown information would have assisted them in prosecuting their claim. What the appellants are trying to do is put inference upon inference upon inference that, number one, there were these emails. Number two, these emails have some unknown subject matter
Well, I think he said that in deposition, one of your people told them that there were such emails, that there were communications between, there were internal communications about these projects.
Your Honor, this matter has been going on since 2003, 2004, and 2005, early 2005, when the contracts were initially entered into. There are hundreds. Each side has produced thousands of pages of documents in connection with the production. I think our side has produced 35,000 documents. I'm sure a similar number has been produced by the other side. There were constant communications going on between, excuse me, the developer and the home builder. At no time during that period of time was there any litigation contemplated. No one was in default. Things were in the normal process. And my client, as a routine matter, deleted emails to clean up their system. I mean, we all do. I do that at my office. I would anticipate that the court does that here. And if, in fact, there is an important email that you would deem important, again, we're not talking about an anticipation of litigation or that there's a reasonable expectation of litigation. We're just talking about the ordinary course. We all clean up our email systems. And that's what the testimony was. Now, there's one email that they allude to from a particular person by the name of Susan Sloan. Susan Sloan was an employee of Adams Homes, in which she sent to an area manager an email that says, where are your biweekly reports as far as the status of a particular project? I forget which project it was. And when the area manager to whom this email was sent was deposed, she testified, we don't have that policy. There are no emails to these biweekly reports. But what the appellants want this court to believe is that because of this one email from Susan Sloan saying, where's your biweekly report, that there are all these emails that contain this adverse information, which are phantom emails of unknown substance. And that's this inference upon inference.
But, counsel, what they've also alleged is that your client continued to delete emails after it decided to file suit up until the time of discovery. Would you admit that once your client decided to file suit, that they had an obligation to retain relevant evidence?
There is no denying that once litigation is pending, there's an obligation to preserve the evidence. And there was testimony that our clients deleted the emails. But let me explain what happened in this particular case. Mr. Gassenheimer refers to an August 2000 date. Well, there was an email from, or a letter, I forget which, from our client to the developer saying, we've got some problems with this, you're not doing what you're supposed to do, you need more people or whatever. The record shows that in November of 2007, 2 or 3 months subsequent to that time frame that they say is the operative date, one of my partners sends an email to the principal saying, we're getting ready to close on a number of lots in Sherman Hills, which I think is in Hernando County. Here's the title commitment. Here's all kinds of issues that need to be resolved for the title commitment. And for us to go to closing, please take care of these issues in the title commitment. That's not anticipation of litigation. So at that point in time, there's no obligation to preserve the emails. Lawyers didn't get involved with the parties until subsequent to January of 2008.
And the litigation started in April.
In April of 2008, yes, sir. And what happened at that point in time is that we contacted Adams Homes of Northwest Florida, and we said, who is involved in these projects, in these various projects? Give us your information. We're not asking you, the employee, to decide what you think is relevant or not relevant. Whatever you have, give to us.
You told them just give you the entire file.
Everything in your file, whether you think it's important or whether you don't think,
emails,
whatever it might be, okay? And they provided that to us. And in the course of discovery, all that information has been provided to opposing counsel. Let me quote one thing from page 14 of our response brief. Excuse me. This is on page 14 of our response brief, and these are questions of a Roxanne Darby, who is one of the area managers who was involved in this transaction. Mr. Gassenheimer was deposing her, and these are his questions from the deposition, and I quote, question, if we wanted to get copies of all the emails that you sent or received to Mr. Spellman, and Mr. Spellman is one of the principals of the developing group, if we wanted to get all of the emails that you sent or received to Mr. Spellman, how would we do that? Answer, well, I thought I provided all that. Question, how did you provide that? Answer, I just went in and made copies of the emails of whatever you had in your system. Yes, yes. Who asked you to get these emails? Mr. Emanuel, my partner. And what happened, Your Honor, in this case is when the litigation ensued, we contacted the client and we said, give us everything you have. You don't make the determination as to whether you think it's relevant or not relevant. That's not your job. Your job is to copy everything and give it to us. And they did. There's just no question about that. So we feel that the appellants in this matter certainly cannot prove any irreparable harm, number one. And number two, they can't prove that the trial court, departed from the essential requirements of the law.
At the hearing, were there any specific emails identified to the trial judge?
The only email, Your Honor, that I can recall was this one email from the Susan Sloan to Roxanne Darby.
That's the only one?
That's the only one. Now, there's another request that the plaintiffs, or excuse me, that the appellants have in this particular matter with the trial court, where they ask for certain records from a software system by the name of Gemini.
Right.
And the court heard that argument. Matter of fact, I think the court heard that argument either the same day or the day before this particular order came out. And what the appellants were asking for in connection with the Gemini software is, you didn't create these documents before, and we want you to now create documents and reports and give those to us. And what Judge Swanson ruled is, no, you're not entitled to documents or reports that have never been created. The court did reserve jurisdiction to determine, and I think a hearing on that issue is set in September of this year, I believe, as to whether or not these folks are entitled to the data from Gemini so they can create their own reports. Their argument is that we, Adams Homes, did not have the financial wherewithal to continue these projects. We have provided them with copies of all of our lender documents, all of the loan agreements, modifications to loan agreements. And is this evidence obtainable? And one of the elements is, can you obtain this evidence that they say is missing? Can you obtain it from other sources? Ask the lender. Don't ask me if I can financially perform. Ask my lender if I can financially perform. They have yet to take a deposition of a lender. They have yet to file a third-party notice of subpoena for documents from any lender. They have yet to take the deposition of the Susan Sloan, who was the author of this email, who made this passing reference to these biweekly reports, that the people that they did depose say, we don't have that process. In addition to that, Your Honor, we have presented, and it's in the record of appeal.
Do you agree with their argument that if you know you're going to file a lawsuit, you're under an obligation to preserve anything that they might be able to use to impeach any of your witnesses?
We feel that there is an obligation to preserve evidence when there's a reasonable anticipation of litigation. Yes, we do believe that, and that's exactly what happened in this particular case. And the preservation.
Mr. Emanuel's request for.
Absolutely. That's the preservation, Your Honor. Print everything that you have and give it to us. That's the retention. Now, does Florida have a formal retention policy for companies? It does not. But what happened in this case is we have an effective retention because we've gotten all of our clients' documents, every one of them. Again, we didn't ask the client, do you think this is relevant? Do you think that's relevant?
You said turn it all over.
Whatever you got, give it to us. And then in that regard.
That request was made at the time the lawsuit was filed.
I'm sorry?
That request was made by Mr. Emanuel generally at the time.
That's my understanding, Your Honor. Yes, sir.
And you're representing that your client was not then continuing to delete emails so that what your firm had was all that existed at that time?
At that time, yes, sir. Now, there may have been, we have a POP3 program, which is a form of email, sort of like a post office, where the server, the host, gets an email, puts it in our mailbox, and as soon as we open it, it's gone from the post office kind of situation. And we have 30,000 plus emails a day within this company. There's no way that we can maintain that kind of information. So traditionally and historically,
well, that 30,000 number is a bunch of spam, right?
There's a lot of spam. There's a lot of emails that talk about you were going to invoice a Mississippi project because our client operates in North Carolina, South Carolina, Georgia, and Mississippi. I mean, those have nothing whatsoever to do with these issues before the court today.
So you have a deletion policy but not a retention policy?
There's no policy of deletion, but what they do is in order to clear up their system and clean up their system so it doesn't slow down, so it doesn't bog down, all the employees routinely, and this is long before this litigation was even thought of, routinely go through and get rid of and delete and then dump or empty their deleted box with those emails that they don't think are appropriate. But when it became understood that the litigation was to be filed, that's when we got, whatever you've got, give it to us. And that has been part of the production. In addition to that, what
There
we
was
did,
a continuing disclosure to you as more documents or emails?
if there were any additional documents, yes. And what we did is we went subsequent to that initial gathering of information, if you will, is we went to the IT independent contractor of our client, and we said, double check these people, please. And he went back and he double checked, and he triple checked, and all that information was, again, subsequently provided to opposing counsel.
Judge Van Norbert's trying to get you to tell us whether, after that initial transfer of information to the law firm, there was some change in the deletion policy so that things that otherwise would have been deleted on a weekly or monthly basis were actually preserved.
There was no change because there was nothing else to even talk about as far. The lawsuit had been filed. Again, Your Honor, this is a contract, or these are contracts whereby they develop lots, we buy lots and takedowns. Okay? And again, we're talking thousands of lots. Once we determined, our client determined that the other side had breached the contract and the lawsuit was filed, there was nothing else to talk about. There are no other emails. So everything that was had when the lawsuit was filed, that's what we gathered across the board. And in connection with production, some of the items obviously were attorney-client privilege or work product, and those were privilege logged. And, there was a hearing before Judge Swanson as far as that issue was concerned. And the court said, well, some of these documents are privileged and some of them aren't, the normal routine kind of thing. I think it's important in the court, Judge Swanson cites the Martino case. Well, let me back up a second. This court in 1987 in the Eister versus Eister case held and decided, and this court quoted Justice Boyd from a Florida Supreme Court 1985 decision that says, it is important to distinguish the concept of a departure from the essential requirements of law from the concept of legal error. On a petition for common law writ of certiorari, the legal correctness of the judgment of which review is sought is immaterial. The required departure from the essential requirements of law means something far more beyond legal error. It means an inherent illegality
Well,
or...
it's not really accurate to say that the legal correctness is immaterial, is it?
I'm quoting what this court said. I'm quoting what Justice Boyd said, Your Honor. Okay? What they're saying is that it's not just an error of law. It has to be egregious. And what it goes on and says, it means an inherent illegality or irregularity, an abuse of judicial power, an act of judicial tyranny perpetrated with disregard of procedural requirements resulting in a gross miscarriage of justice. That's what this court has opined, based upon a Supreme Court decision, is the standard of whether or not you're going to grant cert or not as far as this particular matter is concerned.
Counsel, let's go to the Martino case.
Yes, sir.
Because it seems to me the trial court citing the Martino case was something that well beyond the four corners of the case. That case deals with whether there's a cause of action for spoliation, does it not?
And that's what the majority of the decision was. There was a concurring opinion by Justice Wells and concurred in by then Justice Bell as to the issues that the trial judge adopted. And I would ask the court to review, and what the appellants are asking this court to do is to take a look at New York District, United States District Court for the Southern District of New York or the Eastern District of Kentucky or Montana and take those cases as precedential value, but use a concurring opinion by the Florida Supreme Court as, well, you can't, that's just dicta, you can't pay any attention to that. I would respectfully request that this court read the footnote in the Martino case, that is the footnote on the last page of the concurring opinion. Let me just quote. It says, although reasonable debate is possible over which moment should trigger the duty to preserve, the moment of a discovery request or the moment of a discovery order, it should be clear that any earlier point in the litigation process would be inadvisable. And this is from a Duke Law Review Journal, Your Honor, Judge Nortwood. And it says, if the defendants were obligated to preserve documents the moment they became aware that a suit...
Thank you, Mr. Bookman. We'll have to read that on our own.
Yes, sir. Thank you very much.
Please, court.
How did the trial court depart from the essential requirements of law?
The trial court's order found that there was no duty to preserve evidence in this case, even though there had been issued a request for production of documents for electronically stored information. The trial court ignored Strausser at a minimum. But the critical issue here, I think where we're may not be being clear as to what was destroyed. And if you read Roxanne Darby's deposition in its entirety, what the plaintiffs are arguing and what the deposition says can't be reconciled. She said, I deleted my emails on a weekly basis. So certainly between the time of the December 6th letter declaring contracts in breach and filing the complaint in April, when they had these meetings to gather information, emails had to have been deleted. So we didn't get everything. I urge the court to look at the Alcoa opinion, Consolidated Aluminum versus Alcoa opinion. It's a federal trial court decision because it really explains very well the concept of what's going on here, the deletion of electronically stored information. It's not inconsistent with Florida law because Florida law says there's a duty to preserve evidence, and I think the Torres opinion says it's a duty of a plaintiff to preserve evidence once he knows he's going to sue.
But you're not suggesting that the trial court departed from essential requirements of law because he didn't go outside of Florida law to go look for far and wide for the cases that you've cited?
Absolutely not. I think he ignored Strausser. But here it says, once a party reasonably anticipates litigation, it must suspend its routine document retention destruction policy and put a litigation hold to ensure all the documents are preserved, not what the plaintiff thinks is relevant. That's the issue in this case, is once they declared my client's contract in breach, they should not have been allowed to continue to delete emails because we didn't get everything. And there's no way that in good faith the plaintiffs can stand before you or should have stood before you and told you that we got everything. We didn't get everything. Every single witness I deposed admitted they deleted emails on a weekly or at a minimum every 30 days. And the beauty of electronic information and what the Alcoa opinion discusses is that a company has a unique ability, unlike paper that it's in a senior manager's office, to flip a switch on the server and stop the emails from being deleted and to capture them. And I'm not saying keep all 30,000 emails every week, but at least as to these 8 critical employees who were discussing why they were going to terminate my client's contract, the switch should have been flipped, as discussed in the Alcoa decision, so that we had all the emails, so that this could be a fair trial, tried on a level playing field.
All right, well, thank you very much. We will next